Okay, so you filed your petition, you've attended your first hearing, maybe you've completed everything the judge asked you to do. Now what? If you were anything like me, you probably focused on whatever was right in front of you because you had no idea what was coming next. That's exactly how I felt. I was scared, I was lost, I was overwhelmed. Looking back, I think one of the hardest parts wasn't the work itself. It was not knowing what to expect. If I had understood the process ahead of me, I don't think it would have felt as intimidating as it was. One of the steps in many probate cases is discovery. Hi, my name is Angelique Hamane. I am an educator and not a lawyer. The content of this video is for educational purposes only and not legal advice. When discovery began in our case, I honestly didn't know the first thing about it. To be honest, I didn't even realize we had entered the discovery phase until the other side served us first. When I think about it, those documents were gold. They became my first examples of what discovery actually looked like. When it came time for us to prepare our own discovery request, we weren't starting from scratch anymore. We had terms to Google. We had examples of the format. We had headings to follow. We didn't copy their request verbatim. However, we used a similar structure, but the content reflected our own case and the information we were trying to collect. But seeing how the other side organized everything gave us a much better understanding of what each discovery tool was designed to do. Here's what I learned. So, what is discovery? Discovery is the process where each side gathers information and evidence from the other side before trial. It's one of the ways both sides learn more about the facts of the case, the claims being made, and the evidence that may be presented later. Discovery can include written questions, requests to admit or deny certain facts, requests for documents, depositions, and subpoenas. Let's look at each one. The first discovery documents we received were requests for admissions and form interrogatories. We had 30 days to respond to both. The request for admissions asked us to admit or deny specific statements. The form interrogatories then required us to provide additional information about some of our responses, which included facts, witnesses, and documents that supported our answers. Although they served different purposes, we received them together and had to respond to both. The next discovery documents we received were requests for production of documents, also known as RPDs. So instead of asking us to answer questions, they asked us to produce documents that were related to the case. Depending on what they were requesting, that could include things like medical records, financial records, emails, photographs, contracts, or other documents. Just like the other discovery request, we had to go through each request one at a time and figure out what documents they were asking for. Another discovery tool is a deposition. In a deposition, one side asks another party or a witness questions under oath before trial. Depositions are typically held in an attorney's office or by video conference instead of a courtroom, and a certified court reporter records everything that's said. Unlike the other discovery tools, depositions can be expensive because there's more involved. You may need to pay for a court reporter, transcripts, and sometimes other expenses. One purpose of deposition is to learn what a witness knows before trial and reduce surprises later in the case. Last but not least, subpoenas. They are often used to obtain testimony or documents from people or organizations that aren't directly involved in the case. For example, we use subpoenas to obtain medical records and bank records that we believe would support our claims. Although subpoenas require additional paperwork and procedures, their purpose is to obtain information that may not otherwise be available. One thing that really stood out to me was how different each side approached discovery. We try to answer each request as completely and truthfully as we could because we wanted to fully explain our position. When we received their responses to our discovery request, I realized they had taken a different approach. That was an important lesson for me. I learned that discovery isn't just about answering questions or producing documents. It's also part of each side's overall litigation strategy. Every case is different, and every attorney and self represented litigant may approach discovery differently. Discovery was one of those parts of probate litigation that seemed overwhelming at first. Once I understood the purpose of each discovery tool, it became much easier to see how they all fit together. I hope this overview gives you a better understanding of what discovery is and why it's an important part of the probate process. If you found this video helpful, I'd appreciate if you subscribe to the channel. And if you'd like to see where discovery fits into the overall probate litigation process, I have linked my probate litigation roadmap at the end of this video.